Good afternoon, everyone. I'm Judge Leibson. I'll be presiding over our eviction hearing docket this afternoon. Are there any agreements to any cases?
Yeah, and I just, this is Gwen Horton. I've made an oral motion, talked to the other party. It's Notoria Porter is my client. The other party stated the other day they were agreeable to dismissal.
Okay. Is that the Hogue case?
Yes.
Okay. You're not agreeing to dismiss?
Oh, I thought they were. Okay.
And talk to the other party that was involved in this. And we told her that.
Okay.
Well,
So,
Your Honor, they don't have standing to bring a complaint because it should be in probate, but we can go to trial. I thought we had an agreement.
okay. Are any of you, have any of you, what's your standing to the property? What's your relationship to the property?
We're siblings. Oh, the brother, my sister, this is my brother,
Okay.
and me and my nephew. And my niece, my other brother,
Okay.
and the brother lives in the house.
Have any of you been appointed, executor or executrix, and you cannot bring the suit?
Okay.
Okay, so this will be dismissed. You must go through probate court, get appointed executor or executrix, and then you will have standing to bring the suit. Okay, you can't simply file this without the court giving you the proper authority to do it.
So we
Okay,
need to go down, because the house is still in our parents' name, so we need to go down and get the house put in all our names.
no, ma'am. You want to listen to me.
Okay.
You need to go to probate, file a probate estate, and get appointed executor or executrix, and that will give you the legal authority to deal with the house. Okay? You can't just do things willy-nilly. This is a court of law, okay? Legal procedure has to be followed. So that's what you need to do.
Well, we felt it was one of the.
You might want to talk to an attorney. All right? Here's okay, perfect. We'll give you a card with the Louisville Bar Association's information on it. You can have a free legal authority. Free legal appointment.
Yep. Okay. Go.
Hand me my screen box. Now go freak. Rah.
Anyone else?
Judge, it's my understanding that in the case Ryan Fleming versus Lula Owens, that Miss Fleming intends to dismiss. I was told she would be on the Zoom. I don't see her.
Is that you, ma'am?
No, I am the owner of the house, and these people are wanting, they think it's a big broken eviction, and they're going to be out there, we left, and they're still not out. They're still for me.
Hold on, ma'am. Hold on. What is your name?
I'm in Jackson Smith.
The Judge, we would object to any comments made by Ms. Smith that she's not the plaintiff in this action. She is not listed on the complaint as any of the defendants, and she doesn't have standing here today on this particular case.
And my name's on all.
Please be quiet. I've already asked you once. Don't make me remove you from the courtroom, okay? Is Ryan Fleming here?
Yes, ma'am, I'm here.
Okay. Ma'am, how is the property owned currently?
The property is currently in probate. The loan to the property is still in my uncle's name, and we are waiting now for Ms. Jackson Smith to pretty much get the pretty much refinance the home so that she can get that loan out of his name. And I was advised that Ms. Smith would need to be the one to actually file paperwork to have Ms. Owens evicted from the home. So it's not the estate that wants Ms. Owens out. It is actually the wife of the decedent who wants Ms. Owens out.
Okay.
And just for the court's clarity, at the first sitting, we made a motion to dismiss based on unauthorized practice.
Yeah.
And it was passed.
So. Okay. Are you the executrix of your
Yes.
uncle's estate?
Yes, ma'am.
And let me ask you this. Do you want Lula Owens evicted?
No.
Okay. Then based on that, I will dismiss it. Now, I don't know what's going to happen from here on out. But as I just told those people, you are the person who has the legal ability to act on behalf of this house unless Ms. Smith goes and becomes named executrix instead of you. Do you understand that?
Yes, ma'am. They've tried that already.
Okay. All right. Thank you.
Thank you.
Okay. Anyone else? Next case I have is Blairwood Apartments of Louisville versus Linda Cantor.
Your Honor, Kenyon Meyer for Miss Cantor.
Okay.
Good afternoon, Your Honor. I had trouble unmuting. Ken Dunn for Blairwood Apartments. This was passed to today to have a hearing on the motion to dismiss, which has been filed by Mr. Meyer.
Okay. Would you? Are you?
If it's okay with you.
Okay, that's fine. Absolutely. It's your motion. You go right ahead.
Thank you, Your Honor. So this is a matter that originally came before this court in, I believe January or in March of 2024.
Okay.
You had a hearing on it. I believe it was your case. There was a motion to dismiss based on the fact that I think 3 payments were received by the landlord after the alleged breach, which occurred according to the complaint on or before November 28, 2023. An argument was made of waiver. The other side disagreed with that because it was an automatic deposit. You ruled that they had not returned the money, that they had accepted the payments, and ruled that therefore it constituted a waiver. Then this complaint was filed. The identical breach was relied on. It's, in this complaint, breaches occurring on or before November 28, 2023. And we've simply cited the statute, which says that acceptance of rent constitutes a waiver of the landlord's right to terminate the rental agreement for that breach. And then also cited res judicata. The response was, I think first, there was no adjudication on the merits. I mean, a waiver defense is on the merits. And then second, there was an argument that sometimes in payment cases, if, $2,000 is owed and the tenant pays $1,000, that may constitute a waiver for that case, but that doesn't preclude, a subsequent eviction for the unpaid amount, which I would agree with, but that, the acceptance of payment for $1,000 isn't a waiver of the $1,000 that you haven't paid. So, I think the statute is clear and the 3 rents that were accepted post alleged breach constitutes a waiver, and this case should be dismissed.
Mr. Dunn?
Thank you, Your Honor. I did file an objection. I don't know if the court's had the opportunity to read that.
I have.
I'm sorry?
I have.
Okay. I won't restate everything, but I think the key to this entire matter is the interpretation of the statute KRS 383-65 that's been relied upon. It does speak in terms of a waiver, and it's been construed, and it's been this court's practice consistently and uniformly that that waiver, if there's, say, a partial payment made, that a waiver has occurred, and that then the eviction matter would be dismissed. However, at the same breath, from the bench, there's been advice given to counsel as well as tenants that they'll have the option of refiling the case, so it doesn't preclude that. And we believe that that's the proper analysis of what this statute does. It obviously waived the right to proceed in the prior case, but it was not done on the merits. It was discovered late in the case that the automatic deduct caused rental payments to be made, and therefore that did act as a waiver as to that action. But the practice of this court and the proper interpretation, we believe, of the statute is that it's a waiver of that action. It is not a waiver of matters, for instance, here, where it was not adjudicated on the merits. the allegations made against the Ms. Cantor in this case were never heard by this court. There's been no fact finding as to those allegations. And we believe under the circumstances that the motion to dismiss should be denied and that we should go ahead and schedule this matter, for instance, for next Monday for a hearing on the merits.
So there's one factual issue I need to clarify because this is where I'm confused. So was new notice sent out after the first eviction was dismissed?
Yes.
And was there, or were there any payments accepted after the second notice?
No.
Okay. I think if that is the case, then they can go forward.
Can I address that? Number one, I haven't seen any notice and whether or not, and so I can neither confirm nor deny
Okay.
that we received a notice, but
Obviously,
certainly
you
nothing's
can
been
Argue
filed.
that. Mhm.
But second, on just the pure legal, so I think what's undisputed is we have an alleged breach, same alleged breach in both cases. Undisputed that after the alleged breach and after the landlord knew there was an alleged breach, they accept 3 payments. Don't return them, still haven't returned them.
Mhm. Still haven't returned them?
Correct. Still have not returned any of the payments.
Oh,
so-
well, then
so-
we have a problem.
Wait.
And
You're on.
Hold on, let him finish.
And
Okay.
so the legal question, I think, under the statute, and all I've heard about past practices regards partial payment. But the statute says that if the landlord accepts payment, there is a waiver of the right to terminate for that breach.
Yeah.
That breach is the same breach. They accepted payment 3 times, did not return the money. I think the court, the last time this came, you said, did you return the money? And they said, well, we will return the money
Right.
if you give us a chance. But they haven't returned the money. And there's no,
And I'm not sure, but that portion that you're reading may be for non-payment cases. It may not be for breach of the lease. So I'll have to look that up. Mr. Dunn, you wanted to say?
The only thing, I didn't want the court to be confused. The first eviction matter that was filed, it was discovered shortly before there was going to be a hearing that because of the automatic deduct payment from Ms. Cantor's bank account, that our rental payments had been made.
Right.
And that was the basis. I believe Your Honor was the one that dismissed the case at that time. Blairwood canceled the automatic deduct so it wouldn't occur again and gave new notice on March 11 of this year with the same allegations of breach. Since that time, there has been no rental payments made or accepted in any shape or form. And because of that, we believe that now we're entitled to go forward and that the motion to dismiss should be denied.
It was me, Mr. Dunn, who decided that case. And I specifically remember you saying that the payments will be returned. Are you telling me that that has not happened?
You mean the prior payments for January and February?
The 3 payments that were the reason for my dismissal previously, that you said at the end of our hearing, they will be returned.
That I honestly can't tell you, Your Honor, because I don't know, but I don't think that is material because we are now into a total brand new eviction, which resulted initially from the brand new notice given on March 11, and then afterwards the filing of this proceeding. Since that time, there has been no payment of any sort.
I can't tell you how strongly I disagree with that position, Mr. Dunn. Not only do I think it completely clouds the new one, but you sat here and told me as an officer of this court that you would ensure that that happened. And now you're telling me you don't know if it did and you went ahead and filed new eviction. Do not interrupt me, sir. You went ahead and filed a new eviction without ensuring that that happened? I'm quite frankly astounded, Mr. Dunn. This case is dismissed. Debbie Cook versus Eddie Childress. Okay, so we are here today on the case of Debbie Cook versus Eddie Childress. I'm going to ask both Miss Cook and Mr. Childress to please raise your right hand. Do you swear or affirm that the testimony you're going to give today will be nothing but the truth?
Yes.
Okay. Miss Daly, I'll let you start unless you have any preliminary motions.
No, Your Honor.
Okay, go ahead.
Thank you, Your Honor.
And you can sit, it's okay.
Okay.
Unless you prefer to stand, that's fine.
Well, you know, law school.
I know, I
They should
understand.
stand.
I get it.
This is a complaint for non-payment of rent. You've already sworn in my witness. I'll just start with the
Okay.
questioning. Please state your name for the record. Debbie Cook. And what is your role as the landlord? I collect rent. And in that role, do you have knowledge regarding the rental of 2406 Lindbergh Drive? Yes. Are the defendants Eddie Childress and Rakeisha Barker the tenants in that property? Yes. And did they sign a lease? Yes. And when did they sign that lease? November 1st, 2023. And does that lease call for payment of rent to be made? Yes. And how much is that rent? $1,500 on the first of the month. And it's due the first of every month. And how long was that lease supposed to last? It was a year lease. And does this represent a true and accurate copy of that lease? Yes. Your Honor, we'd like to enter this as Exhibit A.
Okay, thank you.
And have they been paying rent? The tenants, that is, have they been paying rent on this unit? Yes. And when is the last time they paid rent? The last rent was on April 1st of this year. And do you keep any sort of ledger to show that? Yes, ma'am. Is this a true and accurate copy of that ledger? Yes. Thanks. Your Honor, we'd enter this as Exhibit B.
Okay,
And was a notice of non-payment of rent, otherwise known as a 7-day notice, sent to them? Yes, ma'am, on May the 2nd. May 2nd of 2024? Yes, the day after the rent was due. And that was for May rent? Yes. And does this accurately reflect the letter that was sent to them on May 2nd? Yes. Enter this as Exhibit C, Your Honor. Thank you. And are they still in possession of the property? Yes. Have you accepted any money from them since this eviction was filed? No. That's all we have, Your Honor.
at this point, Mr. Childress, do you have any questions for Ms. Cook?
No, ma'am.
Okay, are you ready to testify?
Yeah.
Okay, what would you like to say?
So I've never even dealt with Miss Cook, so it feels kind of awkward because I've already dealt with Joe. So I
Okay.
apologize, Miss Cook, before I start. It's not a reflection on her, but on April, prior to April 1st, I had spoke to Joe back in February about an ongoing persistent issue where the water accumulated from the entrance. I have a video I tried to put on a flash drive before I got here, but I can show the court if you like. But it fills up to about 4 inches of water, and it's impassable from the gate to my entrance.
Your Honor, I'm going to object to this testimony as it's not relevant to whether or not he's paid rent.
Yeah.
Right. So I made this request to the landlord, and this was after he didn't disclose this to me
Again, I'm going to
before.
object because
Sir,
it's still not
yeah.
relevant to whether or not he's paid rent.
So he told me about this issue after I moved in. So then I
Okay, sir,
spoke to him.
I'm gonna sustain the objection, okay? So there's certain things that you have to go through to notify the landlord legally.
did
Okay, how did you do that?
in text message, and he
Okay.
responded.
Okay. Let me, I'll have the sheriff get the text messages from
Okay.
you. Have you seen these, Miss Daly?
No, Your Honor.
I have to
Okay, wait, she's
put it-
gotta see them first.
Yes, sir. I had to put it on.
I understand what this is about, but I'll still object to it because it's not relevant to whether or not he's paid rent.
Deficit. Ma'am, if I may, that was the reason why I told him that I would withhold my rent, because the city cited that as a public nuisance. Also deemed as a health risk because of the standing water. I can't even get to my unit.
Okay,
4 inches of water, I have 3 small kids. I asked him, hey, can you fix this? He told me he was gonna fix it back in February. Still just prolong. The city cited him. He said he was gonna fix it. Prolong. you got feces, you got water, you got mud. There's no way that I can get to my unit with 3 small children. And I've been paying a rent prior to, while this issue was existing. He just was just, and then after I told him about this is when he filed the eviction.
Okay.
And that's when I sent him on April, I received that notice on April the 2nd, so they couldn't have sent it out on April the 2nd. That's the same day. I received it on April the 2nd. And that's when I called him. I said, hey, the only reason why you're doing this is because I told you that.
This is dated May 2nd.
Well, I'm sorry, what, yeah. But the only reason why I'm doing this was because you, May, I wasn't paying May rent. The only reason why you're doing this was because I told you that I wanted to have it fixed and I was gonna use the money for the rent, which I looked up in Kentucky law and said that I could do that.
Did you use the money to fix it?
He told me not to touch his property. He said, you can't touch my property. So I stopped at that point.
Okay. Did you move out?
No, I stayed there and I asked him to fix it. He said it's gonna be scheduled. The inspector came back on the 29th inspection day. It still wasn't resolved.
Okay.
My daughter went to the hospital for AC issues that weren't rectified. I also have records of those. She has asthma. I told him about that. He came through, resolved one issue and left and didn't do nothing about that. My daughter spent 3 days in the hospital.
Okay. So there are certain things that you're allowed to do under the law and certain things you're not, okay?
Yes, ma'am.
And you haven't followed the procedures under the law. Okay, you may have done some things, but you also just can't stay there indefinitely not paying rent.
That was not
okay?
my intention.
Well, are you still there?
I am. He had a month in escrow that I had applied. I applied 2 months in advance when I first moved
Okay.
in. And also,
Sir?
okay.
When are you going to be out?
I have a move-in date for my next unit on July the 1st. Michael Forrest, he's gonna give me a unit. I already spoke to him. That's the only thing I told him in the eviction court. I said, hey, I don't mind it, but they have it. I don't mind it, but they afford me the opportunity to be out the 1st. It'll be rent ready. I'll manage the
Are
property.
you all willing to give him till the 1st to be out?
He won't be out.
Yes or no?
No,
Okay. If I give you judgment today, if he is out on the 1st, will you consider setting it aside and dismissing it? Considering what he has had to deal with there.
are you asking me?
Are you the owner?
He could have July the 1st, but everything he told you is 100%.
Okay, all right. I'm signing the order. Whatever you decide to do is fine. Thank you, Your Honor. Thank you.
Is that it, ma'am?
Yes, sir.
Again, Ms. Cook, this wasn't a reflection of my feelings towards you.
Trevor Rayleigh versus Ebony Jones.
Judge Rebecca Cotton for Ms. Jones, she's present. And Mr. Rayleigh is also present. I have spoken with Mr. Rayleigh.
Do you want to sit or you want to stand?
I did have an opportunity to speak to Mr. Rayleigh. He is here, Judge Pro Se.
Okay.
I asked him for a copy of the notice and for information on how that notice was served. And he did provide that to me. And I was going to make a motion to dismiss based on the content of the notice and on the manner of service.
Okay.
So if you would like to just proceed with the hearing, we can do it that way, or I can hand you the notice and make my motion.
Yeah, why don't, that's a preliminary issue, so why don't you go ahead and hand it to the sheriff and I can look at it and we can decide if it's appropriate, then I will certainly hear the case.
Thank you, Judge. So if you review the complaint, Judge, it states that on March 18th, Mr. Rayleigh is telling the court that he gave written notice to vacate. I request a copy of that. He has checked the box for failure to pay rent. He gave a 30-day notice. The content of that notice is before the court. This notice is to inform Ebony Jones, tenant at 659 Mix, that you must fully vacate the premises by April 18th due to non-payment of rent and late fees for the month of February and March totaling $825. My motion is based on the fact that he did not give Miss Jones opportunity to cure by paying.
Right.
Even if he meant, Judge, which he didn't state on the forcible detainer complaint, that this was a termination of lease. But even if he meant that, it would violate the Young v. House case because it's middle of the month that he gave that notice. We're not able to reach an agreement at this point, so we are requesting the court to dismiss.
Do you want to respond, Mr. Rayleigh?
Yes, Ms. Jones hasn't paid me since she was late piece of February. She hasn't paid me $1 since. I've gotten maybe one response from her. She's had more than enough notice. In January, she told me she was leaving. She wanted out. She didn't live there anymore. Then she decided to stop paying. March, I believe early March, I had spoke to her. She said, I don't feel I need to pay you any rent. And that's the last time I really spoke to her. I've asked her if she wanted to settle up. I don't know where to go because I haven't spoke to her at all. So we're 4 months behind now, upwards of $3,000. I just want her out of the house.
I understand. Sir, and I'm sorry that you're in that situation, but when you file an eviction case through the clerk's office that ends up in this courtroom, if you choose not to hire an attorney, then you are presumed to know the law. And unfortunately, this does not comply with the law. So I have to dismiss this. You have to start all over. You have to comply with the law. And if you don't comply with the law again, I'm going to dismiss it next time. So I'm going to suggest, if you're unable to do it on your own, that you seek the advice of an attorney, because this will not cut it.
I asked for with the.
I cannot tell you. I'm not legally allowed to tell you what's wrong. But he's going to give you a card with the Bar Association's number on it. There are plenty of attorneys that work for plaintiffs in eviction court. So you can certainly contact one of them and they'll show you.
I'd say one thing.
Uh-huh.
I had spoke with an attorney last Monday when we moved this over to a hearing. And then Rebecca, I had reached out to her, Rebecca called me back. She said she was going to advise Ms. Jones then that this was not grounds for a hearing, that Ms. Jones needed to move out. That's why I didn't show any legal, any representation or anything. When we had spoke, she said if I had given her a notice, then Ms. Jones needed to move out, and Ms. Jones
Sir,
understands.
I've made my decision. Thank you. Virginia Starrup versus Michael Borgmeyer.
Good afternoon, Judge. Christopher Bates from the Star. She's present and approaching.
Okay.
Judge, we were here about 3 weeks ago, maybe a month ago, sometime in May. My clients, the Starrups, had filed an eviction notice based on the termination of a 30-day lease.
Okay.
Mr. Borgmeyer had rented a garage on their property. It's where they live. We got about 2 acres. Mr. Borgmeyer rents the garage in the back of the property. When we showed up last time, Mr. Borgmeyer showed up with what he purported to be was a written lease signed by Mr. Starrup. Mr. Starrup was not here last time, only Virginia was. But we disputed the authenticity of this lease. This is not Mr. Starrup's signature. Mr. Starrup, in fact, will tell you that he does not enter into written leases.
Okay.
And so we would ask that you sign the order today.
Okay. Last call for Michael Borgmeyer. Are you here? So I actually have, there is what purports to be Mr. Starrup's signature on the lease. And then there's what looks to be like an addendum, a handwritten note on the end. I'm going to hand those to Mr. Starrup, and I just want him to look at them and tell me that those are not his.
Tom, she's going to ask you, is that your signature? No. Okay. And she's going to ask you, is that your signature there?
It's not my signature. Somebody traced it, maybe.
Okay.
Okay.
No.
Based on that testimony, I will sign the eviction order.
Thank you, Judge.
Thank you. I'm sorry you had to come all the way down here.
We appreciate it.
Okay.
Well,
I'll meet you outside.
Your Honor, do you wish to proceed now or?
Well,
We're-
I'd rather have
we're-
this unless, I mean, is this a true hearing?
Your Honor, this
No,
is
it's not. I'm sorry. We're here on a motion to dismiss, which we briefly discussed last week at the call of the case.
Okay.
So it's not a hearing. It's not a hearing on the merits.
Okay. And then if you two can fill me in orally, I'm fine to go ahead. Tell me, if you would just state the case number and the call of the case for me.
Yes, Your Honor. Case number 24C003567, Hampton Place Housing LLC versus Brian Phillips.
Okay, and we have Mr. Dunn for Hampton Place, and your name, please?
Yes, Your Honor.
My name's Andrew Chandler, representing the defendant.
Okay, and he's here with you in person. Okay, perfect. Your motion?
Yes, Your Honor. We had filed last week an entry of appearance for myself and a motion to dismiss the case on grounds of waiver and
Okay.
factual deficiency. This matter was heard initially on May 6th following a complaint March 18th for non-payment of rent. We maintained and submitted to the court that thereafter, March 18th, on April 2nd, the plaintiff signed a new lease agreement extending my client's stay at the residence through April 2025. And at the signature of that new lease agreement, that they in fact waived their claims to whatever claims they would have had to the breach. Secondarily, Your Honor, within the complaint, on the face of the complaint, the non-payment is issued. The issue they take with is for January and February and March of 2024. We submitted exhibits alongside our motion that for January and February of 2024, that rental assistance was provided by the neighborhood place and received by the plaintiff in this case. And so the facts are deficient to the extent that the rent for that month, to our knowledge, was in fact paid. But ultimately, Your Honor, the strength of our argument lies on the waiver. In addition to what is provided within the Uralta statute, Your Honor, there's clear case law from Daly v. Kelly that where a landlord expressly or impliedly recognizes the continuance of the tenancy, that they thereafter waive whatever claim they would have had to terminate that tenancy on the basis of a breach. And because the breach and in fact filing of the eviction predated the signature of a new lease with my client through 2025, we argue that it ought to be dismissed on grounds of waiver.
Okay, Mr. Dunn?
Your Honor, if I could, by the time I saw the motion, we had discussed with Mr. Chandler that he was going to be making the motion on the basis of this renewal of the rental agreement between Hampton Place and Mr. Phillips. That was the understanding of what we were going to be arguing today. The second portion about factual matters and all that, I'm not prepared to either address that. But as to the first motion to dismiss based upon the new rental agreement being executed, what occurred in this case, I know it's been referred to as a new rental agreement, but it's merely a continuation or a renewal of the rental agreement that Mr. Phillips has had for 1 year. My client advises that because this is a tax credit property, their federal regulations require them to actually have a rental agreement in place for all of their tenants. In other words, they don't do month to month. And that was why, even though this matter was pending in the first few days of April, they had to execute a new a document, which is merely a renewal of the rental agreement that Mr. Phillips signed a year ago. We don't believe that constitutes a waiver under the circumstances. It's merely is required. It's required for them to do it. They have no choice based upon federal regulations. So we don't believe that the matter should be dismissed based on those grounds.
Okay, that's certainly a novel, factual. I mean, I've had apartment complex re-sign a person on a lease, but is this a Section 8, Mr. Dunn?
No,
it's not Section 8. It's actually what's called a tax credit property.
Okay. Yeah, I'm familiar.
And by having that, then the federal regulations kick in, and so it's not technically Section 8. But by doing it as a tax credit property, that then allows them to charge less than what the market rent would be for this type of apartment.
Gotcha. I'm familiar with Family Scholar House, and they work on that same basis with the tax credits. So okay, with regard to that, you're not prepared to discuss the issue of whether the neighborhood place paid January and February today?
My client advises they have not accepted any rent that has been paid. They signed a document so that Mr. Phillips could try to get rental assistance. We were advised that the most he could get was $1,000 when he owed about $3,000 or $4,000. and we would not accept that partial payment, which is why a week ago we asked to go ahead and proceed.
Okay.
So
Do you have any,
here we are.
Your Honor.
do you have anything that shows that it was paid by the neighborhood place?
Your Honor, no, I have the agreement that was entered into by my client and the landlord indicating that they were going to be agreeing to accept that, but I wanted to sort of highlight it. May I respond to a few
Sure,
things?
absolutely.
So the first issue is that last Wednesday, I submitted this motion to dismiss at the request of Mr. Dunn, because at the Monday hearing, it was requested that I put this in writing.
Okay,
The first being the waiver argument, the second being the factual argument.
okay.
So I think that we ought to be able to address both of them here today.
Okay, I'm just, she just brought in the file, so if they are both
Thank you very much.
in the motion, the written motion, then absolutely, yes.
And the rental assistance that Mr. Dunn is alluding to is following the filing of the eviction complaint. Initially, when this was heard back on May 6th, it was passed for June 3rd in order to allow Mr. Phillips the opportunity to get rental assistance. We worked together and managed to drum up about $1,000 in rental assistance. That was denied by, that offer was denied by the plaintiff because it wasn't in full satisfaction of what they alleged was the owed rent. But our attempt to get that rental assistance was present rent. And my understanding is that whenever they entered into this agreement back in February to have the neighborhood place pay for January and February, that was its own payment of rent that occurred in February of 2024. So, I would be happy to put whomever under oath from the plaintiff's office or from my client indicating that rental assistance was in fact paid and received in February of 2024. But that only goes to the factual deficiencies within the complaint alleging that those months were unpaid for rent. In terms of, what was discussed prior to the hearing, in terms of us getting rental assistance, that was just to try to settle the case, and see if they would be willing to voluntarily dismiss.
Gotcha.
And then thereafter, the denial of our offer of $1,000 of rental assistance, we went ahead with the motion to dismiss based on waiver and factual deficiency.
And I guess from our standpoint, Your Honor, in brief rebuttal, if it appears there is some factual dispute, and we would like the opportunity to have a hearing on that if Your Honor is not going to grant the dismissal based on the waiver and the new document that has been signed.
Yeah. Here's what I would like. I'm going to set this for a hearing. Here's what I would like. Let me make a list so everyone knows what I'd like. I would like to see Mr. Dunn, I'll address you, the federal regulation that requires your client to have the agreement on file. I would like to see the agreement signed by your client and the defendant in this case.
Your Honor, if I may, that was filed as Exhibit B.
Okay, it's in here. Thank you.
Yes, Your Honor.
Sorry, since I didn't know this was on, I didn't have a chance to review the file like I normally do, so I apologize to both of you on that.
That's all right.
Okay. I would like to see the defendant's ledger, I guess starting December 12 of 23 to current. And Mr. Chandler, your client should have received and should be able to get a letter from the neighborhood place. There's like a pledge letter that they get saying we're going to pay $1,000.
Yes, Your Honor.
Okay, so that's what I need from you all. Would you all like to do this next Monday?
Next Monday, the 17th, looks good for me.
Okay, the other thing I would ask, one more thing, if they have a copy of the canceled check or any proof that the money was sent and deposited, that would be great.
So I'll contact,
If you can get it.
yes, Your Honor.
Okay.
I'll contact Neighborhood Place and see if they can produce
Thank you,
any substantive evidence that they paid.
thank you. Okay, I'll see you all next Monday.
Thank you, Your Honor.
Thank you, Your Honor.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. He needs an interpreter.
I need an interpreter when I cannot express myself something.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed, we're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am, can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.